Morning.
Good morning.
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 Morning. Okay. Thank you for joining today's session. Again, as usual, please mute yourself and only unmute yourself. Only unmute yourself if you want to say something or if you have a question to ask. Today we are going to talk about forfeiture of benefits. Okay, let me just unmute everybody because I see some people are not muting themselves. Today we are going to talk about forfeiture of benefits. But before we talk about forfeiture of benefits, let's just have a quickly recap on what we spoke about last week. Last week we spoke about a settlement agreement, which is an agreement that divorcing spouses enter into where they state or where they record the terms and conditions of a division of their matrimonial estate. We also learned that in a settlement agreement, spouses can agree on anything as long as it is not against public policy, meaning that the spouses who are married in community of property, they can agree that each party can retain their matrimonial assets. In other words, they don't have to have an equal division of the joint estate. And spouses who are married out of community of property can also agree in a settlement agreement. They can agree that they're going to share everything equally. We also learned about pension interest. And under pension interest, we learned the difference between pension interest and pension benefit. And at this stage, that it is important that you know the difference, which is a pension interest is an interest that has not yet accrued to the member by the time of divorce. Meaning, for example, if you are still employed and you are a member of a pension fund or a retirement fund, and you during the process of divorce, a non-member spouse, your spouse can bring in a claim for 50% if the parties are married in community of property. Can just hold on. If the parties are married in community, if the spouses are married in community of property, the non-member spouse can have 50% claim over the pension, and the pension is going to be paid by the pension administrators. But under pension, a pension benefit, that is a withdrawal benefit that has already accrued to the member. That basically means the pension money has already been paid to the member, and your spouse or the non-member spouse will claim directly from the member and not from the pension administrators. Now let's just continue with today's session. Today's session, as I stated, we are going to talk about forfeiture of benefits. Forfeiture of benefits occurs when one spouse, let's me give an example of spouses who are married in community of property. When a spouse who is married in community of property requests that their spouse forfeit some or all benefits. When spouses are married in community of property, they are supposed to share all assets and the pension benefits in jointly and equally. So a spouse under Section 9, subsection 1 of the Divorce Act, the court empowers, the Divorce Act empowers the court to grant an order for forfeiture of benefits, meaning that one spouse, instead of getting their 50% share from the joint estate, they are either going to forfeit it, all the 50% share or just partial forfeiture. Now, my question to you, student, is can one of you or two, three of you tell us what are the three factors that the court look at in order to determine whether they should consider granting an order of forfeiture or not? The three factors, let's hear from you, Maria. Maria?
Hi, morning, ma'am.
Morning.
It's the duration of the marriage, the circumstances which led to the breakdown of the marriage, and the substantial misconduct.
Okay, thank you. Manaso, 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 can you hear us? Manaso, Manaso, unmute yourself. Yes, you can talk. We can hear you now.
I did unmute. I said she said all. Yeah.
Okay, thank you.
There are three. I wanted to mention one, but yeah, she covered everything.
Okay, mention the one that you wanted to mention.
The duration.
The duration of them. Okay.
Yes. Okay.
Okay, thank you, Manaso. Okay.
Okay, sir.
Okay, you are correct. The three factors are the duration of the marriage, the circumstances that led to the breakdown of the marriage, and any substantial misconduct on the part of either of the spouse. Now, on these three factors, let's first start with the duration of the marriage. With the duration of the, before I continue, Daniel van Wyk, do you want to say something? Daniel?
Yes, good morning, ma'am. I just want to
Morning.
know what page of the study guide are we on right now, because I came in a bit late.
Okay, we are talking about forfeiture of benefits. On the prescribed textbook is chapter 12 from page 135.
Thank you very much.
Okay, thank you. Okay, on the three factors, let's start with the duration of the marriage. In your opinion, as a legal practitioner, what do you think is the reasonable duration that the court can consider? Let me just give two examples. For example, let's say the spouses are married for less than 2 years, and the other example, the spouses are married for more than 10 years or for more than 15 years. Let's assume that one of the spouses committed misconduct. Do you think spouses, where one spouse committed misconduct, but they were only married for less than 2 years? Do you think the duration is a reasonable duration for the court to say, okay, because the marriage has been less than 2 years, we should consider forfeiture of benefit? Or in your view, do you think 2 years is quite a reasonable period that the spouses have been married, and it's going to be unfair for a spouse to lose either the whole asset or a partial asset based on the duration of the marriage? So in your opinion, 2 years, would you say 2 years is a reasonable time to be married, or is a time that the court can consider forfeiture versus, let's use 15 years, versus the spouses who have been married for 15 years, and bearing in mind that in most marriages, not all, but in most marriages, when spouses have been married for 15 years, there is usually a time where there was a healthy relationship, but after some years, things just going south, and the marriage relationship is no longer the way it was at the beginning. So anybody, what is your view when it comes to the duration of the marriage? Anyone? Alfred? Alfred? Alfred, I see your hand is up. Yes, you can talk,
hello.
Alfred. Hello, Alfred.
Yes, ma'am. I'm saying I don't think the duration does matter into details, because now even can be 2 years or 15 years. What matters is that they did had a marriage, and even though according to that the case of us weekly versus weekly, they did stipulated that the duration, it doesn't matter. I stand to be corrected.
Okay, thank you, Alfred. The second student, your name is not written. It is written as guest. Guest. Hello, guest.
Hello.
Hi.
Hello.
What is your name? What is your name? Because it's written as guest here.
After I forgot to put in my name. I think the duration matters because with 2 years, yes, I can say forfeiture it should be applicable at some point if there was a misconduct, because the duration is a bit small than 15 years. With 15 years, you may have started well, and then as you grow into the marriage, things happens. But whatever estate that you have built, you both put effort into it. So 2 years, I think, forfeiture might be granted, because it's not that much of a time. Sometimes there's not that much estate that you can say we have built this legacy together for this long.
Okay, thank you, guests. Mana, so I saw your hand up, but I see now it's no
It is
longer up.
lowered
Let's
now.
hear.
Thank you.
Okay, thank you. Let's hear Abraham.
Okay.
Abraham. Abraham.
Good morning, Miss.
Morning.
I hope everyone's doing well. So, I would say that the duration does not really matter, because in the court case that we had there of Vicar versus Vicar, the court did state that not all three of these factors need to be present, and they are not cumulative. So even if they were, for example, one of the other two factors that are present, the court could grant an order on one of those two factors instead of the duration of the time.
Okay, thank you, students, for your comments. The duration, it does not matter, but practically, it does matter, because our courts, they look at it, and if spouses have been married for 15 years, and let's assume that there was a substantial misconduct, what the court also will look at is, okay, after 15 years, and bearing in mind that there is a substantial misconduct, would it be fair? And now I'm talking about practically how the court are actually approaching forfeiture of benefit. Will it be fair to deny a spouse who has been married for 15 years and then who has contributed into the matrimonial estate? For you to also get an idea how the courts actually deal with forfeiture, when you have time, you can go to SAFLI, is SAFLII.org, and then under search, just search forfeiture of benefits, and then just look at the recent cases to see how the court approach the issue of forfeiture of benefits, and how they approach the issue of duration of the marriage. And also, what I just need to make you aware of is forfeiture of benefits. Let's say for the last 2 or 3 years, if not from the last 5 years, it is something that it is very difficult for spouses to actually succeed in having it granted. The court still do grant it, but they only grant it under exceptional circumstances, and spouses or the plaintiff or the defendant who requested forfeiture of benefits, who requested forfeiture of benefits, they are lucky if the court grants it holistically. In other words, they approve, they grant an order that their spouse forfeit, let's say 50% of their joint estate. So for the purpose of your studies, you need to know the Katie Veka versus Veka, where it is stated that not all of the above factors must be present in determining whether forfeiture must be granted, and then not all of the factors must be alleged in the summons or in the pleadings. But as we sometimes know that when it comes to practically and when it comes to the court, they usually apply things differently. Understand? So it is also very important that when you get time, just also look at practically how do the court actually deal with forfeiture of benefit, especially duration of the marriage. Okay, before we continue, let's hear what Nkosana has to say. Nkosana?
Oh, sorry, ma'am. Sorry to disturb, ma'am.
Okay.
I don't have a study guide, but I have a prescribed book. So which page is it on the prescribed book?
Okay, on the prescribed book is from page 137. And for the study guide, if you want a study guide, you can download it from the My UNISA site. Just go to the
Yeah.
PVL. Yes, just download it. You will get the thing. But the prescribed textbook is under the chapter, the patrimonial consequences of a divorce. And then you just go for forfeiture of benefit, which starts, it's not even page 137, it starts from page 135.
135, yeah.
Yes,
Thank you,
okay,
ma'am.
thank you. Nkosana?
Yes, ma'am. Thanks. And how are you, by the way, ma'am?
I'm okay, and hoping everybody's fine.
Okay, ma'am. Ma'am, I just want to check the rationality as to what are the difficulties that would lead people to go on the process of litigation on the court. I'm taking note of this case that you are referring us to, which is Vetke versus Vetke, where the court is making these grounds that there are certain things that needs to be undertaken in order for a court to grant whatever the relief sought is sought by one of the parties in a marriage. Because now one of the things they are highlighting is the duration of the marriage. But in one of the chapters when we're reading, I think you said that a spouse is having the right to go to the court and say that, no, I don't want to be in this marriage. So the court would give the discretion, but the court is not making an order when it comes to this. So I just want to check if a spouse, one of the party within the marriage, no longer happy, and then is making that point very clear and explicit that I do not want to be in this marriage, and then what could be the reason that would lead for the spouses to go to a court? Because I know that there are grounds for of a marriage, which is irretrievable breakdown. So if there is that evolution from another one citing that I'm no longer happy, then why should they go to that extreme? Thank you.
Okay. Okay, thank you for your question. Firstly, I must state that a spouse who wants a forfeiture of benefit must specifically state it in the pleadings. Secondly, there is a difference between when a spouse says, I am no longer happy.
Ma'am, we can't hear you.
You are muted, Kathleen.
Guys, please make the quiet.
You are muted.
Guys, can you mute our mics, please?
Ma? Okay.
Someone's baby is making noise.
Students?
Yes, ma'am.
Yes,
Can
Yes,
hear
can you
you.
hear us?
I apologize for that. The screen just went off, so I had to rejoin again. I apologize for that. Okay.
Accepted. Apology
Okay, ma'am.
accepted.
Okay. Let me start what I was saying. Firstly, I was saying that the court will not force a spouse to be in a marriage that they no longer want to be part of. Because of this, if a spouse says, I am no longer happy with my spouse. A wife says, I'm no longer happy with my husband, and I no longer want to be part of this marriage. This will fall under one of the reasons or the factors that led to the breakdown of the marriage. But what led to the breakdown of the marriage does not necessarily mean that spouse who's filing for the divorce because they are no longer happy, they must forfeit a share of the matrimonial estate. A spouse who does not want their partner, their spouse, to get a share from their estate must specifically request it in the pleadings. And by requesting it, they must also show why is it that their spouse must forfeit either everything or a partial a share of the matrimonial estate. So, Nkosana, I'm not sure if I'm answering you by saying just being unhappy in a marriage and wanting out of that marriage does not necessarily mean you also don't have the right to share your 50% of the estate. If you're married in community of property, I can be unhappy with my husband and I want out of that marriage, but I still want 50% from the joint estate because that is what I am entitled to by virtue of our marriage contract.
Oh, okay, ma'am. Is the last question that I want to ask, because I think now you have shed the light in relation to this question that I was asking. So, this judgment, this case, case law of which it was talking about the patrimonial benefits forfeiture, where one spouse they were in a marriage, be it that it's a community of property. Let us assume it's a community of property, but because of one was not happy within that marriage, and then they would go through the process of divorce and then would want to regain the 50% status, despite the fact that what he or she elected to go out of the marriage. So does that necessarily mean the other one who feels aggrieved and feels that there were some prospects of working the marriage around, but the other one was refusing, then does have the right to go to the court to say, no, I'm denying this particular person this 50%. So the court is having a jurisdiction to entertain such issues.
Okay, the court is having a jurisdiction to entertain such issues, but there are reasons for forfeiture. It's not a good enough reason. Over and above that, I still believe that I can save my marriage. For them to succeed in forfeiture of benefit, they must also show that why is it that your spouse did not should not get their share from the matrimonial estate. So although Vika versus Vika said you do not have to prove or to show all the factors, it is also important to note that just alleging one factor and it is just not good enough. For example, let's take the duration of the marriage. Let's say the parties have been married for 2 years, and then after 2 years, and the spouse says, I am no longer happy, I want out. If the other spouse says, okay, because of the short duration of marriage and because of your reasons, it's just that you do not want us to work on this marriage. the court will have to determine, is this good enough for the plaintiff to forfeit their share of the matrimonial estate? And then in my view, it is not good enough. What happens in the circumstances where their spouse also contributed? And we have learned when you have studied that you cannot lose what is yours. Ne? But if you are married income of property and then you are entitled to 50% of your spouse pension. So let's assume that it is the wife who is the plaintiff, and then she's the one who has contributed. Let's say she was a housewife, and then she contributed by being a homemaker. And then after 2 years, she realized that, you know what, the marriage is not working, and I want out. But I want out, and I also want 50% share of my husband's pension fund. Would it be fair to say, okay, because it has now been 2 years that we've been married, and it is you who is saying you want out of this marriage, and because of that, the husband says, okay, forfeit 50% of my pension. Would it be fair for this wife to forfeit 50% of the pension, even though she contributed in the joint estate within that 2 years period? And my argument here will be, okay, maybe the husband, instead of saying forfeit 50% share of my pension, bring an argument in court that she should forfeit maybe the share that the husband accumulated before they got married, and only share in the pension that the husband acquired from the date they got married up until the day of the divorce. So in summary, I will say, yes, you don't have to allege or prove all the factors, but you must have good reasons. And merely saying, I wanted to save the marriage and she did not want to save the marriage, that is not a good enough reason for a spouse to lose what they are entitled to in terms of the law. But maybe you can argue in terms of the percentage of what they are supposed to get. What is also important is the duration here, because a spouse who has been married for 15 years and that spouse, let's say the wife again, was the homemaker for 15 years. And after 15 years, she wants out of the marriage, and the husband is saying, but there is a possibility that we can save the marriage. It's going to be unfair to say, okay, forfeit what I accumulated before we got married and only get what or what I accumulated during the process or while we were still married. So this thing is not as easy as in the court will say 1, 2, 3 factors and then that's it. There is a lot that needs to be considered, but what also is the most important that you must bear in mind is that the courts are not allowed to use forfeiture of benefit to deviate from what a spouse is entitled to. There must really be good reasons why their spouse must not get what they are entitled to in terms of the law. I hope I managed to answer you. Let's go to Lebogang. Lebogang, Efinia. Lebogang?
Thank you. I'm covered.
Okay, you are covered. Thank you. Buinelo?
Morning, ma'am. How are you?
Morning.
I just need to understand something clearly here. So we're saying that duration of the marriage is one of the reasons why a spouse would forfeit their benefits, right? So
no. Okay, let me just quote. It's not one of the factors that the court will consider over and above the reasons that are brought regarding why forfeiture should be granted.
But it still needs to be motivated.
Yes.
Like that the other spouse should be able to say why they would want the court to do this because of the duration.
Yes.
Okay, no, I'm clear.
Okay,
Thank
thank you. Okay, Manaso.
Yes,
Manaso. Yes,
thank you.
Manaso.
Yeah, can you hear me?
Yes, we can hear you, Manaso.
Oh, okay, thanks. Mine is like this. Now that we're talking about a divorce, yes, as a result of a misconduct, it brings in this phenomenon called no-fault divorce. How would you define this no-fault divorce? I take it it's like a divorce where there is no fault. This is my a layman's understanding of this phenomenon. Thanks.
Okay, no fault divorce basically means that divorcing spouses cannot be said, for example, you, the wife, it is your fault that the marriage has broken down, or it is you, the husband, it is your fault. The courts take the view that when a marriage breaks down, it is because of the conduct of both parties. Let me give an example, which is quite common, cheating. A spouse can say, okay, I was very faithful in this marriage, and my husband or my wife went out to and cheated. Because of that, it is their fault that the marriage broke down. But then the wife will bring an argument that, but I was also unhappy in the marriage. I was not getting any attention. And if you had conducted yourself like a proper husband and like a proper partner, I would not have went out and cheated. And as a result, it is not just me by cheating who is at fault, but also your conduct in the marriage. It was also wrong, and it is the one that forced me to do whatever I did. So in the end, it is both of us who are wrong, which led to the circumstances that led to the breakdown of the marriage. But when we link misconduct with a forfeiture of benefit, for the purpose of forfeiture of benefit, misconduct is taken into account. For the purpose of the filing for the divorce, terminating the marriage, it does not matter who was wrong. What matters is, can it be proven that the marriage has irretrievably broken down? So, but now if a spouse claims or wants forfeiture of benefit, one of the things that they need to prove is there was a substantial misconduct in the marriage. The spouse, okay, let me say the innocent spouse will have to prove that the other spouse conducted a substantial misconduct to the extent that they must forfeit either all or partial or some asset, but it is going to be unfair on the innocent spouse if forfeiture of benefit it is not granted. What we are talking about now is leading me to what I wanted to ask you, which is the circumstances that led to the breakdown of the marriage. I wanted to ask is, in your opinion, what do you think are or should be the circumstances that are so that the court must consider forfeiture of benefit? For example, would you say a spouse who has cheated, it is only fair that they must forfeit some of their patrimonial benefits? And then if the answer is yes, how would you deal with the situation whereby that spouse who cheated also contributed in the joint estate, for example, or in the matrimonial estate if they are married with the accrual system? The issue of circumstances that led to the breakdown of the marriage. Which circumstance must be that that spouse must forfeit a share of the matrimonial estate? Okay, let's hear what S is saying. S saying.
Good morning, ma'am.
Morning.
I have two questions. The one is when a couple is married in CLP, during the commencement of marriage, one spouse transfers their assets in a trust account. Upon their divorce, does the other spouse still acquire the 50% of those assets in that account?
Okay, yes. Remember, when you get married in community of property, you now have one joint estate. So if you take the matrimonial assets and you transfer them into a trust, that trust is going to be a share. So the innocent spouse can bring a court application to have that trust dissolved because it was opened and the assets were transferred without their consent. The only exception is when a spouse who is in a COP marriage has a business and they acquire assets in the name of their business in their capacity as a director of their business. While you are still married, your business, the PTY, does not form part of your joint estate. So as a spouse, you can create a trust in your capacity as a director, and that trust, it is not opened by you in your capacity as a husband, a member of a joint estate, but it is opened by your company, and you are authorizing it as a director of your company, and those assets will not form part of the joint estate.
Does that also is that in COP, a marriage in COP?
Okay, repeat that because I keep on hearing COP.
No, I'm saying if one spouse is a director of the company, of the PTY limited company, and upon that capacity they transfer their funds in a trust account. So this occurs even during a COP marriage.
Yes, during a COP marriage. Spouses who are married a COP, they are allowed to open a business, and a business is a separate legal entity. While you're still married, it does not form part of the joint estate. It only forms part of the joint estate during death or during divorce. So as let's say it's the husband, a husband who has opened a company and is a director in the company will be able to create a trust and transfer all the company assets into that trust without the consent of the wife, because the wife is not a member of that company. So yes, through the company that is possible, but remember, the husband will not be doing that in his capacity as a husband or a member of a joint estate. He will be doing that through the company and in his capacity as a director of the company.
Okay, thank you so much, ma'am. Just one more question. If a couple is married in COP and applies to the High Court to change their marriage contract to A and C, during this change to the marriage, does the one spouse still forfeit the 50% of the estate, or can they retain what is theirs?
Okay, it will depend on what the spouses have agreed upon. If they bring a court application to change their marriage regime, the forfeiture will not be applicable. If each party wants to retain their own assets, then that is what they're going to do. But to change from in community to out of community of property, the parties will first have to divide their joint estate before they enter into a new marriage contract.
Okay, thank you so much, ma'am. I appreciate it.
Okay, thank you. Gaugelo?
Yes, ma'am. How are you?
I'm okay. Gaugelo?
Ma'am, I've got a question. It just got when the previous guest was talking with regards to trust, but yes, related to marriages as well. I just want to ask if spouses are married in community of property and they both had kids before they got married, and then again in a marriage they then had kids as well, and then they do a trust of their assets for, say, maybe it will be for the children. Will the trust cover the kids outside the marriage as one question. And then if it happens like that, and then to a point whereby they decide to divorce, what will happen with the trust after they divorce or when they decide to get divorced?
Okay, during the marriage, if the spouses jointly decide to create a trust, it is up to them to decide who are going to be the beneficiaries. If they decide to exclude the children who were born out of marriage, those children are not going to benefit. If they include them, they're going to benefit. So this is not something that is regulated by the law. This is something that is the parties will have to decide who's going to be the beneficiary of the trust. Regarding the divorce, if the parties entered into a valid trust. A trust is a separate legal entity. It will not form part of their divorce because that's a separate legal entity.
Okay, thank you.
Okay, thank you. Can I please ask that we go back to discussing forfeiture of benefits and what I asked, that in your view, in your own opinion, what do you think are the circumstances that the court should consider when dealing with forfeiture of benefits? Lorraine? Lorraine?
Yes, ma'am. Thank you so much. I would think adultery will still be another example where you can forfeit your benefit. I would say, like, for example, if we are married and you go and impregnate someone else outside, for me, in that way, I will think you will forfeit those benefits because now you have another responsibility outside that you are bringing to our marriage. So I can decide that because of adultery, that you went outside and do 1, 2, 3, I'm divorcing you and I'm taking everything that belongs to me.
Okay, thank you for that. Ibrahim, I see your hand is up. Ibrahim? Ibrahim? Singh? Singh, is your hand up? Singh, is your hand up? Okay. Winelo? Winelo, is your hand up?
Yes, my hand is up, ma'am.
Okay.
I think the court should consider should probably be if say for instance if say for instance I caused, maybe I wanted to the one spouse wanted to maybe injure or maybe kill the other spouse because of the benefit or something like that. I think the spouse can apply in that regard. I don't know.
Okay, thank you for that. Gaugela, is your hand up? Is your hand up before I continue? Gaugela?
No, it's not up, ma'am.
Okay, thank you for that. Okay. The circumstances that led to the breakdown of the marriage, we can link it to any substantial misconduct on the part of either spouse. In the case of Veka versus Veka, they set two important things that will actually answer what I've just asked now. The first one is the court should first determine whether the party against whom the order is sought will benefit if the order is not made, which is a factual determination. So here's an example. A spouse commits adultery, but that spouse who has committed adultery and then now has a child outside of the marriage, the first question will be, will they, what is the court will they unduly benefit if forfeiture of benefit is not granted? Now, what happens in the circumstances where that very spouse contributed substantially or contributed equally in the matrimonial estate? remember or note that having an affair, that does not necessarily mean that because the spouse has an affair, they now need to be punished. And how they are punished is by saying, okay, because now you had an affair, your punishment will be you are going to lose a certain portion of what you are entitled to in terms of the law. And then, so a spouse who has cheated but has contributed, or besides cheating, there is no any other reason why they should forfeit. The court are usually reluctant to order forfeiture under those circumstances. So in the case of Vicar versus Vicar, two important factors that must be taken into account and that you must know for the benefit of your exam is the court should first determine whether the party against whom the order is sought will benefit if the order is not made. If this has been determined, the second thing is the court must determine whether the benefit is undue. A spouse who is married in common of property and has a child out of wedlock will benefit from the joint estate. So factor number one, the factual determination, we have now determined that yes, he will benefit. Now, the second question is, will the benefit be undue? And that is where you get to see, okay, will the forfeiture of benefits be fair or not? Though the court, they don't look at whether it's fair or not. They have to determine whether they're going to undue, is it going to be an undue benefit from their side. Let's use an example of a housewife. A housewife who has an affair, but who has an affair and does not contribute into the joint estate financially, but has contributed non-financially by being a housewife, a homemaker. Would we say it's going to be? Would we say she's going to unduly benefit if forfeiture of benefit is not granted, although financially she never contributed? In your view, let's use the example of a housewife who has an affair, and let's say she gets impregnated by the boyfriend, and let's assume that the parties, the wife and the husband, has been married for 10 years or for 5 years. In your view, do you think that wife will undue benefit if she is granted 50% of the joint estate because she's the one who had an affair? She never contributed financially, but she did contribute in the joint estate. If a client comes to you and say, this is my situation as a husband, I don't want her to get anything because she never contributed financially and she is now pregnant by her boyfriend's child. So what is your view on that? Should a housewife who cheated benefit from the joint estate? Ndumiso? 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 Ndumiso, can you hear me?
How are you?
I'm okay, Ndumiso.
Yes, sorry to cut you off here. I wanted to ask something before the question you just asked. What if the other spouse, let's say the parties are married in community of property, and then the other spouse is declared a prodigal during the subsistence of the marriage? Would it have an effect of whether the forfeiture of patrimonial benefits are granted or not?
Okay. It will have an effect if with forfeiture, the spouse who brought in the claim is able to convince the court as to why their spouse should share. Let's say, for example, their spouse have mismanaged the finances of the joint estate to such an extent, to such an extent that if an order is granted that they get 50% of the joint estate, the innocent spouse is going to be unfair on the innocent spouse. So if they can prove that by mismanaging the finances and the assets of the joint estate, the innocent spouse has already lost a lot, and it is only fair that forfeiture it is granted, failing which that spouse who has now been declared a poacher that will unfairly benefit from the assets or from the finances of the innocent spouse.
Okay, thank you so much.
Understand? Okay, thank you. Kgaugelo, is your hand up? Kgaugelo? Kgaugelo?
No, no, ma'am.
Okay, thank you so much. Tupullo? 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 Okay, Tupullo. Ndumiso, is your hand up? Okay, thank you, students. Students, I asked a question. Can somebody please answer? A housewife who gets impregnated by a boyfriend and who for the last 10 years has been a homemaker, has been a housewife and been responsible for the household responsibilities. Do you think it's going to be fair if the husband says they must forfeit because financially they did not contribute? So the house, the pension and everything, they did not contribute, but their contribution was only by being a housewife. And now the marriage has failed because of their affair. Let's hear Winelo.
Ma'am.
Winelo?
Ma'am.
Yes, Winelo.
Yes, I think no, it would be unfair if the husband says the wife should forfeit their benefit because she cheated and now she has a child, because even though she did not contribute financially, but she contributed as a housewife. Probably the husband has what he has now because of her contribution as a housewife. So it would be unfair for the husband to want to take away. It would still be the same as if she was also working and contributing financially. The fact that she was not contributing financially is not reason enough for me for her to forfeit whatever she did. If adultery alone is not a reason for her to forfeit, then she shouldn't forfeit because she was not contributing financially to the estate.
Okay, thank you for that, Winelo. Let's hear from Cynthia. Let's hear from Cynthia. Cynthia? Cynthia?
Hear me?
Yes, we can hear you, but there's a noise in your background.
I'm in the office. Oh my goodness.
Okay, send it on the chat. Send it on the chat, your
Okay.
question. Okay, let's hear from Andile.
I
Andile?
actually wanted to explain. It wasn't a question, but I want to explain how I understand.
Okay.
I wanted to answer.
Okay, thank you. Cynthia? Andile? No, Andile? Andile? Okay,
Hello?
Bulawa? Okay, Andile. Who's speaking now? Andile?
Andile speaking, yes, ma'am.
Yes, Andile.
I think it wouldn't be fair, ma'am, because in some instances, the husbands do not want the wives to work. So some housewives are not housewives by choice, but because the husband states that, no, I can afford, I'll do 1, 2, 3, 4, 5 for you. So they also contribute because they let go of things that they want to do. and then they take care of the husband. So he goes to work, clean and everything. They take care of the house, they take care of the kids. So even though he brings money, but emotionally, physically, the wife is the one that does all the hard work. So I don't think it will be fair. Thank you, ma'am.
Okay, thank you for that. Guest, PVL2601, guest.
Okay, sorry, ma'am. It's Precious, ne?
Okay, Precious.
Yes. I think in that case it won't be fair. I think that's where Mr. and Mrs. Gumete's case come in. You know, where Mr. Gumete went Mrs. Gumete approached the constitutional court to protest the case where they were married for 40 years, and she was a homemaker for 40 years. She never did any work, and then she felt that she was being mistreated because she's a woman, and the man now wants his ex-husband wants her ex-husband now wants everything. I think that's where the case come in. In this case, in your question, no, it won't be fair, because we look at whether or not they were married in community of property, don't we, ma'am?
Yes, we look at
Yes.
not whether they were married in community of property or not, but
Or not, yeah.
the matrimonial estate, because forfeiture of benefit is also applicable where the spouses are married out of community of property without with the subject to the accrual system.
Oh, first of all, they are not married in they're married out of community of property.
No, they
yeah?
can get married out of community of property or out of community of property with the accrual system or in community of property. Because if they're married out of community of property subject to the accrual system, it means the housewife will have a claim, an accrual claim over the difference between the two estates.
Oh, okay. Yeah, no, it won't be fair. No, it won't be fair.
Okay, thank you.
Ma'am. Thank you
So much. Let's hear from Precious. Okay, Mbulawa. Mbulawa.
Hello, ma'am. Yes, ma'am.
Yes, Mbulawa, we are listening. Mbulawa.
Hello, can you hear
Mbulawa.
me?
Yes, we can hear you.
Yes, I'm saying I don't think it will be fair because the issue of having tickets came after the contribution that the woman has made. In other words, the woman's contribution preceded this act of infidelity. So it will have no bearing regarding whether the woman should be excluded from benefiting or not. So it's out of question.
Okay, thank you so much.
That's it all.
You are correct, student. The fact that she did not contribute financially and that she had an affair, it does not necessarily mean that if forfeiture of benefit is not granted, the housewife will unduly benefit from the matrimonial estate. So when answering this question, please remember that these two factors, that you first need to make a factual determination, and then secondly, you need to do the value judgment of whether there's going to be an undue benefit or not. And also for the benefit or for the purpose of this course and for your exam, you just need to know also the examples of benefits which can be forfeited and benefits which can be forfeited, and a benefit which cannot be forfeited is what is yours. A spouse can only forfeit a share of the other spouse estate. Let's say, for example, spouses who are married in community of property. We know that in community of property means the parties have equal share in the joint estate. But let's say, for example, one spouse who inherited a property and that property forms part of the joint estate by default, let's say from the parents who never left a will. So the other spouse, if forfeiture of benefit is granted, they can forfeit a share of that house. But if the parties themselves own a property, and let's say one spouse was responsible for the bonds and the other spouse was responsible for the rates and taxes, and that spouse was able to prove all the factors that the court need in order to prove that, or in order to give an order of forfeiture of benefit, that spouse cannot lose a share of their own house, even if the contribution that they did in the joint property was just paying rates and taxes and maybe contributing towards maintenance of the property. Understand? Now, is there anybody who has any question on any aspect of forfeiture of benefits? Khadija? Khadija? Khadija?
Good afternoon, ma'am.
Good morning, Khadija.
Sorry, good morning, ma'am. I have a question regarding what would be considered substantial misconduct on the part of a spouse.
Okay, an example of substantial misconduct can be a variety of mixed factors. Let's say, for example, let's use an example of a pension. During the marriage, the spouse withdrew, secretly resigned, withdrew their pension, and they used for their only benefit. And over and above, let's say they also had an extra marital affair, and they were never sleeping at home, and at home they never contributed at all. So besides the fact that they withdrew their pension and used it for their own benefit and also with third parties, their girlfriend, even in the joint estate, their conduct was such that the innocent spouse is the only one who was doing major contribution building the joint estate, and it is going to be unfair and undue if the other spouse is not, if an order is not granted, that the other spouse get in a share, or if an order for forfeiture of benefit is not granted, because basically it will mean that their spouse who never contributed, their spouse who used his own pension will now have 50% share of the innocent spouse's pension and estate, while their spouse is not getting anything from the spouse who actually conducted such substantial misconduct. So practically what the courts do, they just look at holistically what is it that this spouse did that it will be so unfair if we give an order that the estate must be shared in line of their marriage contract.
Thank you, ma'am.
Okay. PVL 2601 guest, Rachel, I think. PVL 2601. PVL. Okay, Mzwake.
Oh, hello, ma'am. Hello.
Yes, Mzwake. Yes,
no,
you
it's
are
Precious.
Okay, Precious.
Yes. I was saying I really need to understand this. I don't know if the question is off the topic, but then I wanna know, like, to whom does the forfeiture apply to? Like, to whom does it apply to?
Okay. The other spouse, for example, during the process of divorce, the plaintiff, who is the wife, for example, or the plaintiff, let's say the plaintiff is the husband for divorce, and in their pleadings, they request that let's say it's the husband, they request that the wife, who is the defendant, forfeit a certain share. So forfeiture can apply on both of the spouses. The spouses themselves. So the plaintiff can file for divorce and say, I want division of the joint estate, and the defendant can respond by saying, no, I want forfeiture of benefit. So it applies on both parties. It's just that one spouse must be the one who claim or who bring a claim for forfeiture of benefits.
Okay. Thank you, ma'am.
Okay. Nzwake?
Yes, ma'am. I wanted to ask, what are other examples that make up substantial misconduct besides adultery?
A spouse who vanishes. It happens sometimes that you will get married and your spouse will just vanish. You don't know where they are, and they will just reappear after 5 or 10 years. So there you don't know whether there was adultery or not. So that is also another one factor of substantial misconduct. A spouse who never contributed at all and who just vanished, and the marriage relationship only lasted because there was a marriage certificate, but the parties were not living together, and then there was no communication at all, there was no relationship at all.
Okay, thank you, ma'am.
Okay, thank you. Nonhlanhla?
Hi, ma'am.
Good morning.
Yes, I'm still confused a bit, and I think this question was also in the last assignment we did, right, about forfeiture of benefits, especially if you are married in community of property. Are you saying that if someone brings the forfeiture of benefit thing, there's the court will never, or it's rare for the court to allow the other spouse to leave, like to forfeit 50%, the one that they are entitled to because of the marriage contracts that they have? Are you also saying that one can never forfeit what they brought into the marriage?
Okay. Firstly, with the last one, yes, you cannot forfeit what is yours. So what you brought into the marriage will forever be yours. And regarding the court granting forfeiture of benefit when spouses are married in community of property, I am saying the court can grant the order, but practically they grant it under exceptional circumstances. And on this one, I referred you to the website Safely, where I said, please, when you get a chance to go there, search for forfeiture of benefits, and then just read court judgment. Just read how the court approach this topic, and how the court, or let me say, in those cases where the court granted either partially or full forfeiture of benefit, what reasons did the court give there? What I know for a fact is practically forfeiture of benefit is not easily granted. Many spouses are lucky if the court grants them what they are requesting, because the courts are not allowed to deviate from the marriage contract of the parties. So if you are married in community of property and you do not want your spouse to get 50% of the joint estate, you must give good and compelling reasons for the court to allow that and to grant you forfeiture of benefits.
Okay, thanks. Thank you. It makes sense.
Okay, thank you. Lituma? Lituma?
Yes, ma'am. I was just checking quickly. The format of exam, is it the MCQ or the written one? I'm not clear on that one. Thank you.
Okay, you'll get an announcement for that. I'm going to be honest. I don't set up the exams questions. I only do the assignment questions. So once that has been sorted out, you will get an announcement. So I don't want to commit myself and say there'll be MCQ or not. At the present moment, I'm not sure what the format is going to be. But what I know is okay. What I know is please. Okay.
Okay, ma'am. On which topics are we supposed to focus on to prepare for the exam?
Okay, read all the topic, all the prescribed topics in PVL in your course, and also please peruse the study guide because it also says there what sections you can skip and what sections you must mostly concentrate on. Like for example, with forfeiture, you must know vicar versus vicar. It is very important.
Okay, thank you so much.
Okay,
ma'am.
thank you. We are going to have Manaso. Manaso. We can moving Manaso. Petile.
Hello, ma'am.
Hello, ma'am.
Hi.
Okay.
Okay, go on, Manaso.
It's Manaso
I'll come
here.
after you.
I'm sorry,
Okay,
I
Manaso.
didn't unmute myself.
Okay.
Hello, okay. Hello.
Yes, we can hear you,
Can you hear
Manaso.
me?
Yes.
Okay, thank you, ma'am. I was saying mine is a general one. Please, if I'm out of topic, say so. I will accept it. Here's my question. You have something like a Criminal Procedure Act of 1977, and you have a Criminal Procedure Amendment Act of 92. Please advise me. Do I have, if I want to consult, do I consult them at the same time, or I'm only focusing on the amended part of it, or on the amended act? Thank you.
Okay, remember with acts, legislation, when they amend, they sometimes don't amend the whole act. They will amend certain section. So you must, most of the time, especially if you go to SAFLI, they have updated legislation, which is the amended one, but they will say, okay, these are the amended sections, but the others will still remain the same. So you will get the amended version, which only the only sections which have been amended, and then you will also get the legislation which does not have amended section, but you also get the legislation which is now comprehensive. It has incorporated the amended sections.
Oh, thanks.
Are you answered?
Thanks a lot. Thanks, ma'am.
Thank you. Just keep on checking
100% answered.
Okay, thank you.
Okay.
We are going to have
Okay,
the
sir.
last was Petile.
Oh, hello. Hi.
Hello, Petile.
Good morning. I just wanted to confirm something of which I think I heard you say. Did you say if either of the partner is prodigal, they can forfeit? For example, somebody who just spends their money, rough and without showing any responsibility, can they forfeit?
Okay, yes. If the innocent spouse can prove that if forfeiture is not granted, if the innocent spouse can prove that forfeiture is not granted, that the prodigal spouse is going to unduly benefit, then yes, forfeiture will be granted. But remember, with forfeiture, the innocent spouse must prove that the other spouse will unduly benefit if forfeiture is not granted. So that is the key word. Will the other spouse unduly forfeit if unduly benefit if forfeiture of benefit is not granted? Understand? Okay, we are going to have the last three one. We're going to have Tupullo, Nonhlanhla, and Khadija, if your hand is still up. Tupullo. 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 Okay, Ronald.
I'm here.
Okay,
My microphone is a problem. Yes, I just wanted to ask that if it happens that after divorce, the guilty party has already benefited, and maybe the innocent party realizes that if they had taken their matter to court, they could have been granted forfeiture. Is it possible that they can go back to claim or to reverse whatever that has already happened.
Okay, there is nothing in law stopping a divorced spouses from bringing a court application, but whether they're going to succeed is another question on its own. In my own view, I doubt the court will grant that order, because remember, during the process of divorce, the assumption is you applied your mind and you know what you were doing, and also if you were legally represented, you received proper and good legal advice. So you can't, once a divorce has been granted, and say, oh, I've changed my mind because now I realize that, you know, my former spouse, now I realize that my former spouse should not have benefited, because by bringing a court application late, once the divorce has been granted, it's going to look like, you know what, now you have realized that, okay, maybe your spouse's, your ex-spouse's life is much better than what you thought is going to be. And then now you are bringing this court application as a way of, I don't know, maybe punishing them or so. And also, again, it's going to make it very difficult to prove these factors, because once the divorce has been granted, whether they had an affair, whether how long the duration of the marriage was, it will really no longer matter during that time. Understand? Thank you. We are going to have Topolo. Okay, Topolo is the one who was talking now, right?
Yes, I'm answered. Thank you.
Okay, thank you. Ronald? Ronald? Okay, Ronald. Manaso, you will be the last one. Manaso?
Oh, yes, thank you. I was saying mine is just to add. I think I read somewhere where it says a forfeiture order will be granted together with a decree of divorce. In other words, they go hand in hand. Yeah, this is what I wanted to add.
Yes, okay. Remember, forfeiture of benefit only applies during the divorce process. So once it has been granted, it's going to form one of the court, it's going to form part of a court order. And spouses who terminate their marriage, they get a divorce decree once the marriage has been terminated. Okay. Students,
Yes,
thank you for
that's
joining.
how I understood it.
Yes, that's how it works. Students, thank you for joining today's session. If you have any questions or if you want to talk to me, feel free to send me an email. My email address is monarkn@unisa.co.za. Have a good day ahead. Thank you. Goodbye.
May I repeat the email? Is MONAR.
Okay,
Ma'am, please don't go. I want to ask you a question.
Okay, please, if you have any question for me, send me an email. My email address is M for mother, O for orange, N for nose, A for apple, R for rose, K for Kathleen, N for Ntabiseng @unisa.ac.za. Thank you so much, and we shall meet again on the next session. Have a good day ahead. Goodbye.
Thank you, ma'am.
Bye. Thank you so much.
Hi, ma'am. Thank you.